And why I think it puts the association in a great spot is if you think of it from like the plaintiff attorney perspective, they're coming after the association, and a lot of times they can force a settlement because the cost of defending yourself is just so much every month and it wears the association down. And so the board will be like, hey, we just got to get rid of this, give them whatever they need, and they come up with a settlement they wouldn't normally come up with.
Thank you for joining us for another episode of Policy Party. I'm Negar Sharifi, joined by Phil Masi. Today, we're going to be discussing a policy that has become popular in the past few years, known as a legal defense policy. This policy steps in when the association otherwise does not have coverage on either their general liability or directors and officers policy. So, Phil, run us through an example of when this policy would pick up a claim.
Sure. So anytime your general liability or directors and officers policy denies a claim, most of the time our clients would then have to hire their own attorneys, pay their own defense, and obviously pay whatever settlement that ends up being. Legal defense policy is kind of nice because what it does is it steps in, gives like an attorney on retainer, gives you the attorney. The attorney will defend the association. It's really unlimited defense cost there. It does not pay what the ultimate settlement is, but at least the defense piece of that claim or that denied claim is picked up, which can be significant for an association.
I've had this come in handy oftentimes for D&O type claims. So what I have found that a little bit of a gray area is when some sort of property damage occurs and the general liability carrier doesn't want to pick it up, but some citing that it's a D&O claim, parts of it resemble a D&O claim, but then the D&O carrier is excluding under property damage. So oftentimes while those two carriers duke it out, I send it over to the legal defense policy and they have assigned counsel to go ahead and defend. Now, sometimes one of the carriers will ultimately step up to the plate and pay it, but in those cases, at least they can, respond to the lawsuit in a timely manner.
Yeah, I mean, I think that there's common exclusions that we see, like a directors and officers policy requires a claim to be reported within a certain amount of time. So we'll often see boards dealing with stuff themselves and not telling us in time on the D&O claim, and they get excluded for late reporting. That's a common exclusion. And then you're dealing with the claim yourself. This would at least give you defense cost in the event that acurred. Pollution liability, if you're not buying pollution coverage, that's another common one when we see pollution claims, Legionella, stuff like that. Another thing that I think is how it sets the association up. So I'll give you kind of an example. And this is really the biggest application for me. If some of our accounts are more challenging from a liability placement. So let's say they've had significant dog bite issues in the past, multiple canine related claims, kids bitten, bad claims, you may find that the carrier is unwilling to provide coverage for canines, or they might have a dog bite or an animal exclusion, and there's just no way we can get the coverage on there because of the claim history. In that scenario, you would absolutely want to buy a legal defense policy, because if a dog bite issue occurred down the line, that policy is going to at least pick up the defense side of that. And why I think it puts the association in a great spot is if you think of it from like the plaintiff attorney perspective, they're coming after the association, and a lot of times they can force a settlement because the cost of defending yourself is just so much every month and it wears the association down. And so the board will be like, hey, we just got to get rid of this, give them whatever they need, and they come up with a settlement they wouldn't normally come up with. Whereas if you have the legal defense policy, it's like it's kind of creates a defense against this, because you're paying unlimited defense costs. So the plaintiff attorney is now, not able to wear you down. And there's really no pot of gold at the end of that because there's no coverage. So they're ultimately going to have to get a judgment against the association. So you're usually able to negotiate from a stronger position and then get a better settlement or no settlement if you can get out of the claim with the attorneys you're using, versus just bleeding out money and then being forced into a settlement.
Another benefit of the legal defense policy is that they often provide free legal advice. So it might not even have anything to do with the claim that you plan to report or a claim that was excluded on one of the other policies. But if you just have an issue going on and you don't want to pay the association attorney, most of the policies I see provide anywhere between like 10 to 15 hours of free legal advice, which is something that you can get through us, or it's the information is provided on the policy. So for any associations where, as Phil mentioned, you have some pretty major exclusions in the policy and there's just no way to get you coverage, or at least no way to get it at a price point that makes sense or is feasible, a legal defense policy is definitely something to consider.